As promised, being a man of my word, I told you guys that I would articulate to you the three different meanings of the United States, all right, that have been identified by the Supreme Court. And so I'm going to go ahead and do that video. So we're going to skip ahead in this. This will be the meaning of the United States in three separate contexts as affirmed by the Supreme Court. So the Supreme Court even recognizes that there are three different definitions for the United States. And once upon a time, I cannot find the document, where I actually found a philosopher who was in fact a professor at a university. I can't recall his name. I'll have to look for the document. But he does in fact state emphatically that he had discovered over 26 different versions of the United States, from the United States of America to the United States listed in like the Federalist Papers, so on and so forth. So things can get really confusing when they use the same nomenclature per se, but use different definitions for it, causing mass hysteria amongst the masses because they just can't seem to wrap their head around the fact that these people are putting different definitions to the same title over and over and over again. And the professor, the philosopher that was working for a college, a university at the time, stated that 26 may just be touching the tip of the iceberg of how many different correlations and definitions the word United States actually has, from King George's United States to the Scottish-Irish Reichs, United States that they had created. So very interesting, but we're going to break it down. Meaning of the United States, the meaning of the United States, three geographical definitions of the United States. Most of us are completely unaware that the term United States has several distinct and separate legal meanings and contexts, and that it is up to us to know and understand these differences. To use them appropriately and to clarify exactly which one we mean whenever we sign any government or financial form, including voter registration, tax documents, etc. If we do not, we could unknowingly, unwittingly, and involuntarily be creating false presumptions that cause us to surrender our constitutional rights and our sovereignty. And again, I want to stress to the point that you don't have constitutional rights. You have constitutionally protected rights. These rights are unalienable. They are not granted to you by man. They are not privileges. They are not benefits, ladies and gentlemen. They are unalienable rights granted to all men, for all men were created equal, because none of you are hermaphrodites. And I don't give a shit what kind of sexual orientation you have scrupled up in your head, boy, girl, boy, whatever. You cannot manifest yourself. You did not manifest yourself. And because of that, we are all created equally, period. A whole lot of heat, pressure, and hopefully love was involved in making you. Then again, a lot of people were conceived after a long night of drinking and concert going, and so who knows if it was love or lust, but nevertheless, a whole lot of heat and pressure is how you were created, all right? You went to the party with your dad, you got shot out of a cannon, you went home with your mom 9 months later, woohoo, all right? Some screaming infant shitting in diapers and making a ruckus around, and just think it was all caused by a long night of partying. Nevertheless, you were shot out of a cannon at some point in your life, unless you're an unfortunate test tube baby and never got that ride. For that, you can always visit an amusement park, Six Flags, highly recommended, and you can be shot through a roller coaster and get the same effect of being shot through a cannon if you were unfortunately a test tube baby. Okay, if we do not, we could unknowingly, unwittingly, and involuntarily be creating false presumptions that cause us to surrender our constitutional right and our sovereignty. The fact is, most of us have unwittingly been doing just that for most, if not all, of our lives. Much of this misunderstanding, and legal ignorance has been deliberately manufactured by our corrupted government and the public school system, or as I identify it, the public fool system. It is the fact that our public disservants want docile sheep who are easy to govern, not high-maintenance sovereigns capable of critical and independent thinking and who demand their rights, all right? We have become so casual in our use of the term United States that it is no longer understood, even within the legal profession, that there are actually 3 different legal meanings to the term. In fact, the legal profession has contributed to this confusion over this term by removing its definitions from all legal dictionaries currently in print that we have looked at. See Great IRS Hoax for details on this scam. Most of us have grown up thinking the term the United States indicates and includes all 50 states of the Union. This is true in the context of the U.S. Constitution, but it is not true in all contexts. As you will see, this is the 3rd meaning assigned to the United States, to the term United States by the United States Supreme Court. But usually, when we use the term United States, we actually think we are saying the United States, the lowercase united, uppercase states, case proper states, okay? Which indicates sovereign, and the first word united being all lowercase. As we are generally thinking of the several states of the Union of States, as you will learn in this section, the meaning of the term depends entirely on the context, and when we are filling out federal forms or speaking with the federal government, this is a very costly false presumption. First, it should be noted that the term United States is a noun. In fact, it is a proper name and title we, the people, gave to the corporate entity, non-living thing of the federal central government created by the Constitution. This, in turn, describes where the United States Federal Corporation, referenced in Title 28 U.S.C. subsection 3002-15A, was to be housed as the seat of the government in the District of Columbia, not to exceed 10 square miles. Constitution, Article 1, Section 8, Clause 17, to exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square, as may by sessions of particular states and the acceptance of Congress become the seat of the government of the United States, and to exercise likely authority over all places purchased by the consent of the legislator of the state, in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings, and underlines added. So, where are our forts, magazines, arsenals, and dockyards? Okay, one of the things to keep a society, if you will, humble and honorable is for them to be fully armed at all times. One instance I can think of is over there in Switzerland. Although they're a neutral country, all their countrymen have been issued arms. Now, they don't get to keep them at their house. They have a stockyard where they keep these things. But I find it very interesting that their form of government does, in fact, respect their people because they have provided ample ammunition and tactical defense tools to keep the checks and balances. Again, they're not allowed to keep them at their house. Americans have a right to keep and bear arms, to defend themselves. And furthermore, people throughout the world have a right to defend themselves by any means necessary against any tyrannical forms of government or mob or gangsters or mafia or drug cartels, including animals, not limited to just man, although man is one of the most destructive animals ever conceived or created. And people go, well, Derek, where are you coming up with man being an animal? Well, if you look at the USC definition, the United States Code, Title 7, 136, it clearly articulates that any vertebrate or invertebrate mammal, including but not limited to man, okay? So man is animal, and it makes sense. Although we are highly intuitive and we are able to create, manipulate, do all kinds of cool, crazy stuff that most of the animal kingdom is not privy to. Although apes are making a marvelous leap into the future by manufacturing their own tools for getting out ants out of the ant hills, or termites, or getting fruits and vegetables that have certain things on them. And in fact, watching the Joe Rogan show just recently, I recently discovered that some orangutans are actually now using spears to fish. So, although I don't necessarily believe in evolution per se, as the scientists would have us believe that we evolved from ape and that's how man became created, I don't buy into that malarkey. Although the evolution of people, man, animals evolving to exercising critical thought process by seeing and replicating what man does is obviously prevalent at this point. And I constitute that or consider that as evolution. So that's pretty interesting and pretty neat. Let's move on. Let's move forward. I had to get myself a cup of coffee. Below is how the United States Supreme Court addressed the questions of the meaning of the term United States. See Black's Law Dictionary. In the famous case of Hoven and Allison Co. versus Evatt, E-V-A-T-T, I think I'm saying that correct, Evatt, 324 U.S. 652, 1945, again, it's a case after 1936, the courts ruled that the term United States has three uses. The term United States may be used in any one of several senses. It may be merely the name of a sovereign occupying the possession analogous to that of other sovereigns in the family of nations. It may designate the territory over which the sovereign of the United States extends, or it may be the collective name of the states which are united by and under the Constitution. Hoven and Allison Co. versus Evatt, E-V-A-T-T, 324 U.S. 652, 1945. We will now break the above definitions into its three contexts and show what each means. So, let's break it down. All right. U.S. Supreme Court definitions of the United States in Hoven. It may be merely the name of a sovereign occupying the position analogous to that of other sovereigns in the family of nations. This, in that context, is under international law, and it is illustrated by quotation marks, capital U, lowercase N-I-T-E-D, capital S, lowercase T-A-T-E-S, with an asterisk alongside of it, a single asterisk, okay, and it's all in quotation marks. These United States, okay, once again in quotation marks, when traveling abroad, you come under the jurisdiction of the president through his agents in the U.S. State Department, where U.S. refers to the sovereign society. You are a citizen of the United States, like someone is a citizen of France or England. We identify this version of the United States with a single asterisk after its name, United States with an asterisk, throughout this article. Okay, so it's not what the Supreme Court did with the asterisk. It's what these individuals chose to do to articulate the United States in that context. So we are perfectly clear. Number two, it may designate the territory over which the sovereignty of the United States extends, or, and this is under federal law, federal forms, okay? And again, they're illustrating United States with two asterisks in this context for this writ. The United States, the District of Columbia, possessions and territories, okay? Here, Congress has exclusive legislative jurisdiction. In this sense, the term United States is a singular noun. You are a person residing in the District of Columbia, one of its territories or federal areas, enclaves. Hence, even a person living in one of the sovereign states could still be a member of the federal area and therefore a citizen of the United States. This is the definition used in most acts of Congress and federal statutes. We identify this version of the United States with 2 asterisks after its name. United States with 2 asterisks throughout this article. This definition is also synonymous with the United States Corporation found in Title 28, U.S.C. 3002, 15A, B, and C. Okay? And the third and final one, as defined by Congress, or as defined, or interpreted, I should say, well, they're allegedly not supposed to interpret. They're supposed to take the context and the meaning for which Congress created the definition for the United States, and they're supposed to affirm that that's what the Congress had intended. As the collective, remember, this is the third and final United States recognized by the Supreme Court. As the collective name for the state, as the collective name for the states which are united by and under the Constitution. This is the important one. Constitution of the United States with 3 asterisks. So, the several states, which is the United States of America, referring to the 50 sovereign states, which are united under the Constitution of the United States of America. Now, the Constitution of the United States of America happened after the Reorganization Act of 1871. Need to be really, really clear about that. I had a lawyer who's like, oh, prove it to me, Derek, that there's 2 United States constitutions. Well, that wasn't really fucking hard because the Constitution was for the United States of America. And then after 1871, it was the Constitution of the United States of America, okay? Of, the etymology of the word of, meaning not with, all right? If we're going to break it down etymology-wise. Constitution of the United States of America. The federal areas within these states are not included in the definition because the Congress does not have exclusive legislative authority over any of the 50 sovereign states within the Union of States. Rights are retained by the states in the 9th and 10th Amendment, and you are citizens of these United States. This is the definition used in the Constitution for the United States of America. We identify this version of the United States with 3 asterisks after its name, United States, throughout this article. So those are the 3 distinct definitions from the Supreme Court that I promised that we would identify this evening or this morning and get to and share with you guys. The U.S. Supreme Court held to clarify which of the 3 definitions above is the one used in the U.S. Constitution when it held the following. Note, they are implying the 3rd definition above and not the other 2. The earliest case is that of Hepburn versus LZ, ELLZEY. 2 Cranch 445, 2 LED 332, in which this court held that under that clause of the Constitution limiting the jurisdiction of the courts of the United States to controversies between citizens of different states, a citizen of the District of Columbia could not maintain an action in the Circuit Court of the United States. It was argued that the word state in that connection was used simply to denote a distinct political society. But, said the Chief Justice, as the act of Congress obviously uses the word state in reference, which is a lowercase, all lowercase state, in reference to that term as used in the Constitution, it becomes necessary to inquire whether Columbia is a state in the sense of that instrument. The result of the examination is a conviction that the member of the American Confederacy only are the states contemplated in the only Confederacy only are the states contemplated in the Constitution and exclude from the term the the signification attached to it by writers on the law of nations. This case was followed in Barney versus Baltimore, 6 Wall 280, 18 LED 825, and quite recently in Hooe versus Jameson, 166 US 395, 41 LED 1049, 17 Superior Court reports 596. The same rule was applied to citizens of territories in New Orleans versus Winter, 1 Wheat 91 4 LED 44, in which an attempt was made to distinguish a territory from the District of Columbia, but it was said that neither of them is a state in the sense in which that term is used in the Constitution. In Scott versus Jones, 5 Howe 343, 12 LED 181, and in Miners Bank versus Iowa X-Rail District Prosecuting Attorney, 12 Howe 113 LED 867, it was held that under the Judiciary Act permitting writs of error to the Supreme Court of the state in case where the validity of a state statute is drawn in question, an act of a territorial legislator was not within the contemplation of Congress. Downs versus Bidwell, 182 U.S. 244, 1901. The Supreme Court further clarified that the Constitution implies the third definition above, which is the United States with 3 asterisks as illustrated by us, when they held the following. Notice that they say no part of the United States within the meaning of the Constitution, and that the word the implies only one rather than multiple geographic meanings. As the only judicial power vested in Congress is to create courts whose judges shall hold their offices during good behavior, it necessarily follows that if Congress authorizes the creation of courts and the appointment of judges for a limited time, it must act independently of the Constitution upon territory which is not part of the United States within the meaning of the Constitution. O'Donoghue versus United States 289 U.S. 516 53 S period CT period 740, and this case was held in 1933. And finally, the U.S. Supreme Court has held that the Constitution does not and cannot determine or limit the authority of Congress over federal territory, and that the only portion of the Constitution that does in fact expressly refer to the federal territory and therefore the statutory United States is, in fact, Article 1, Section 8, Clause 17. Notice they ruled that Puerto Rico is not part of the United States within the meaning of the Constitution, just like they ruled in O'Donoghue above that the territory was no part of the United States. In passing upon the question involved in this and kindred case, we ought not to overlook the fact that while the Constitution was intended to establish a permanent form of government for the states, which should elect to take advantage of its condition and continue for an indefinite future, the vast possibilities of that future could never have entered the minds of its framers. The states had but recently emerged from a war with one of the most powerful nations of Europe, were disheartened by the failure of the Confederacy, and were doubtful as to the feasibility of a strong union. Their territory was confined to a narrow strip of land on the Atlantic coast from Canada to Florida, with a somewhat indefinite claim to territory beyond the Alleghenies, where their sovereignty was disputed by tribes of hostile Indians supported, as well as was popularly believed by the British, who had never formally delivered possession. 182 U.S. 244, 285. Under the Treaty of Peace, the vast territory beyond the Mississippi, which formerly had been claimed by France since 1762, had belonged to Spain, still a powerful nation and the owner of the great part of the Western Hemisphere. Under these circumstances, it is little wonder that the question of annexing these territories was not made a subject of debate. The difficulties of bringing about a union of the states were so great, the objection to it seemed so formidable that the whole thought of the convention centered upon surmounting these obstacles. The question of territories was dismissed with a single clause, apparently applicable only to the territories then existing, giving Congress the power to govern and dispose of them. Had the acquisition of the other territories been contemplated as a possibility, could it have been foreseen that within little more than 100 years, we were destined to acquire not only the whole vast region between the Atlantic and the Pacific Ocean, but the Russian possession in America as distant islands in the Pacific? It is incredible that no provision should have been made for them, and the question whether the Constitution should or should not extend to them have been definitely settled. If it be once conceded that we are at liberty to acquire foreign territory, a presumption arises that our power with respect to such territories is the same power which other nations have been accustomed to exercise with respect to territories acquired by them. If, in limiting the power with which Congress was to exercise within the United States, which in this one would be the 3 asterisks, it was also intended to limit it with regard to such territories as the people of the United States, again with 3 asterisks, meaning the constitutional republic, should thereafter acquire, such limitations should have been expressed. Instead of that, we find that the Constitution, speaking only to states except in the territorial clause, which is absolute in its terms and suggestive of no limitations upon the power of Congress in dealing with them. The states could only delegate to Congress such powers as they themselves possessed, and as they had no power to acquire new territory, they had none to delegate in that connection. The logical inference from this is that if Congress had power to acquire new territory, which is conceded, that power was not hampered by the constitutional provisions. If, upon the other hand, we assume 182 U.S. 244 286 that the territorial clause of the Constitution was not intended to be restricted to such territory as the United States then possessed, there is nothing in the Constitution to indicate that the power of Congress in dealing with them was intended to be restricted by any other of the provisions. If those provisions are inhabited by alien race differing from us in religion, custom, laws, methods of taxation, and modes of thought, the administration of government and justice according to Anglo-Saxon principles may for a time be impossible. And the question at once arises whether large concessions ought not to be made for a time, that ultimately our own theories may be carried out and the blessing of a free government under the Constitution extends to them. We decline to hold that there is anything in the Constitution to forbid such actions. We are therefore of the opinion that the islands of Puerto Rico is a territory appertent and belonging to the United States, but not a part of the United States, with the 3 asterisks, meaning the constitutional United States, within the revenue clause of the Constitution, that the Foraker Act is constitutional so far as it imposes duties upon imports from such islands, and that the plaintiff cannot recover back the duties exacted in this case. Downs versus Bidwell, 182 U.S. 244, 1901. The 2 political jurisdictions, nations within the United States. Another important distinction needs to be made. Definition 1 above refers to the country United States, but this country is not a nation in the sense of international law. This very important point was made clear by the U.S. Supreme Court in 1794 in the case of Chisholm versus Georgia, 2 Dallas, U.S. 419, 1 LED 440, 1793, when it said, "This is a case of uncommon magnitude. One of the parties to it is a state, certainly respectable, claiming to be sovereign. The question to be determined is whether this state, so respectable, and whose claim soars so high, is amendable to the jurisdiction of the Supreme Court of the United States. This question, important in itself, will depend on others more important still, and may perhaps be ultimately resolved into one. No less radical than this do the people of the United States form a nation." A clause so conspicuous and interesting should be carefully and accurately viewed from every possible point of sight. I shall examine it, first, by the principles of general jurisprudence, second, by the laws and practices of practical states and kingdoms. From the law of nations, little or no illustrations of this subject can be expected. By that law, the several states and governments spread over our globe are considered as forming a society, not a nation. It has only been by a very few comprehensive minds, such as those of Elizabeth and the fourth Henry, that this last great idea has been even contemplated. Thirdly, and chiefly, I shall examine the important question before us by the Constitution of the United States and the legitimate result of that valuable instrument. Chisholm versus Georgia, 2 Dallas, U.S. 419, 1 LED 440, 1793. An earlier edition of Black's Law Dictionary further clarifies the distinction between a nation and a society by clarifying the difference between a national government and a federal government. And keep in mind that the American government is called federal government. National government, the government of a whole nation, as distinguished from that of a local or territorial division of the nation, and also as distinguished from that of a league or confederation. A national government is a government of the people of a single state or nation, united as a community by what is termed the social compact and possessing complete and perfect supremacy over persons and things, so far as they can be made the lawful objects of civil government. A federal government is distinguished from a national government by its being the government of a community of independent and sovereign states, united by compact. That's PIQA. It's PIQUA, Branch Bank versus Knope, KNOUP, 6 Ohio State 393. Black's Law Dictionary, Revised 4th Edition, 1968, page 1176. Federal government, the system of government administered in the state formed by the union or confederation of several independent or quasi-independent states. Also, the composite state so formed. In strict usage, there is a distinction between a confederation and a federal government. The former terms denote a league or permanent alliance between several states, each of which is fully sovereign and independent, and each of which retains its full dignity, organization, and sovereignty through yielding to the central authority a controlling power for a few limited purposes, such as external and diplomatic relations. In this case, the component states are the units with respect to the confederation, and the central government acts upon them, not upon the individual citizens. In a federal government, on the other hand, the allied states form a union not indeed to such an extent as to destroy their separate organizations or deprive them of quasi-sovereignty with respect to the administration of their purely local concerns, but so that the central power is erected into a true state or nation, possessing sovereignty both external and internal, while the administration of nations' affairs is directed and its effects felt not by the separate states deliberating as units by the people of all, but by the people of all. In their collective capacity as citizens of the nation, the distinction is expressed by the German writers by the use of the two words Städtebund, Staatenbund, Städtebund, and Bundesstatut, Bundesstaat, okay, Bundesstaat. The former denoting a league or confederation of states, and the latter a federal government or state formed by means of a league or confederation. Black's Law Dictionary, revised 4th edition, 1968, page 740. So, the United States, the country, is a society and a sovereignty, but not a nation, under the law of nations by the Supreme Court's own admission. Because the Supreme Court has ruled on this matter, it is now incumbent upon each of us to always remember it and to apply it in all of our dealings with the federal government. If not, we lose our individual sovereignty by default, and the federal government assumes jurisdiction over us. So while a sovereign American will want to be the third type of citizen, which is a citizen, capital C, of the United States, and on occasion a citizen of the United States, he would never want to be the second, which is a citizen of the United States, with the two asterisks. A human being who is a citizen of the second is called a statutory U.S. citizen under Title 8 U.S.C. subsection 1401, and he is treated in law as occupying a place not protected by the Bill of Rights, which is the first 10 amendments of the United States Constitution. Below is how the U.S. Supreme Court, in a dissenting opinion, described this other United States, which we call the federal zone. All right, here we go. I take leave to say that if the principle thus announced should ever receive the sanction of a majority of this court, a radical and mischievous change in our system of government will result. We will, in that event, pass from the era of constitutional liberty guarded and protected by a written constitution into an era of legislative absolutism. And the second court case. The idea prevails with some, indeed. It has found expression in arguments at the bar that we have in this country substantially two national governments, one to be maintained under the Constitution with all of its restrictions, the other to be maintained by Congress outside independently of that instrument. By exercising such powers of absolutism as other nations of the earth are accustomed to. And the third ruling. It will be an evil day for American liberty if the theory of government outside the supreme law of the land finds lodgment in our constitutional jurisprudence. No higher duty rests upon this court than to exert its full authority to prevent all violations of the principles of the Constitution. Downs versus Bidwell, 182 U.S. 244, 1901, Justice Harlan dissenting. United States is a corporation and a legal person. The second definition of the United States above is also a federal corporation. This corporation was formed in 1871 under the Reorganization Act. It is described in Title 28 U.S.C. 3002, 15A, B, and C. Okay, so we'll get into that. It's Title 28, Judiciary and Judicial Procedures, Part 6, Particular Proceedings, Chapter 176, Federal Debt Collection Procedures, also identified in Subchapter A, Definitions and General Provisions, okay? Section 302 definitions 15 is United States means A federal corporation, an agency, department, commission, board, or other entity of the United States, or and C, an instrumentality of the United States. All right. And that's why I say A, B, and C are all intermingled. They're one and the fucking same. All right. To include one thing is to exclude all others. And they didn't fucking include the Union of States in that definition of the United States in Title 28, 3002, 15A. So they have excluded it. All right. The U.S. Supreme Court, in fact, has admitted that all governments are corporations when it held. Corporations are also of all grades and made for varied objects. All governments are corporations created by usage and common consent or grants and charters which create a body politic for prescribed purposes. But whether they are private, local, or general in their objects, for the enjoyment of property or the exercise of power, they are all governed by the same rules of law as the Constitution and the obligation of the instrument by which the incorporation is made. The Constitution is the corporate charter. One universal rule of law protects persons and property. It is the fundamental principle of the common law of England that the term freemen of the kingdom includes all persons, ecclesiastical and temporal, incorporate, politicae, or natural. It is a part of their Magna Carta to INST 4 and is incorporated into our institutions. The persons of the members of corporations are on the same footing of protection as other persons and their corporate property secured by the same laws which protect that of individuals to INST 46 through -7. No man shall be taken, no man shall be disseized without due process of law. In a principle taken from the Magna Carta, infused into our state constitutions, and is made inviolable by the federal government by the amendment to the Constitution. Property of Charles River Bridge versus proprietors of 36 U.S. 420, 1837. If we are acting as a federal public official or contractor, then we are representing the United States Federal Corporation under Title 28, 3002, 15A, B, and C. That corporation is a statutory U.S. citizen under Title 8 U.S.C. subsection 1101 A22A, which is completely subject to all national but not federal law. A corporation is a citizen, resident, or inhabitant of the state or country by or under the laws of which it was created, and of that state or country only. 19 Corpus Juris Secundum, Corporation, subsection 886 in 2003. Federal Rules of Civil Procedure 17B says that when we are representing that corporation as officer or holding an office or as an employee, we therefore become statutory U.S. citizens completely subject to federal territorial law. For parties, Rule 17, parties, plaintiff, and defendants' capacity. B, capacity to sue or be sued. Capacity to sue or be sued is determined as follows. 1, for an individual who is not acting in a representative capacity by the law of the individual's domicile, and 2, for a corporation by the law under which it was organized, and that's number 2 is the most important poignant part, because that is where they're alleging that you're an officer of that organization. And remember, if you volunteer to be an agent, an agency of that, and fill that office, then you are due and owing no pay. When you finally figured out that you volunteered all this time and you try to go back and get back pay and all that stuff, they're going to say, hey, you bared the benefit, you were the officer, you volunteered, and you suffered because of it, and suffer is voluntary, which means we owe you nothing. We owe you nothing because you didn't pass the litmus test. You fell for one of our traps. It's far easier to go along and get along and just be a U.S. citizen than it is to actually stand in the Republic. Okay, the Republic is somewhere nobody wants to stand because it comes with a lot of accountability and responsibility. Okay, those are the facts. Plaintiff and defendant capacity, public officer. Amen, Keith. Glad to have you aboard, buddy. And so as not to take away from the context, we'll go ahead and read 3. 3, for all other parties by the law of the state where the court is located, except that a partnership or other unincorporated association with no such capacity under the state laws may sue or be sued in its common name to enforce a substantive right existing under the United States Constitution or laws, and b, Title 28 U.S.C. subsection 754 and 959A govern the capacity of a receiver appointed by the United States court to sue or be sued in a United States court. Federal Rules of Civil Procedure 17b. Yet, on every government, any level document we sign, ergo Social Security, marriage license, voter registration, driver's license, BATF, 4473, etc., they either require you to be a citizen of the United States, or they ask, are you a resident of Illinois or Nebraska, Colorado, Texas, They are in effect asking you to assume or presume the second definition of the United States with 2 asterisks when you fill out the form. But they don't want to tell you this because then you would realize they are asking you to commit perjury on a government form under penalties of perjury. They, in effect, are asking you if you wish to act in the official capacity of a public employee or officer or fill the office of a federal corporation. The form you are filling out, therefore, is serving the dual capacity of a federal job application and an application for benefits. The reason this must be so is that they are not allowed to pay public benefits to private humans and can only lawfully pay them to public statutory employees, public officers, office holders, and contractors. Any other approach makes the government into a thief. See article below for the details on this scam. And with that, I will let you guys go for the evening. But again, I wanted to articulate the 3 different United States as identified by the Supreme Court. And thank you again for all your support. Love you guys, and we'll talk to you soon.